Before I turn today's presentation over to our speakers, I would like to go over a few housekeeping items. Today's program will last approximately 75 minutes, followed by a question and answer session. We will respond to written questions at the end of the program, time permitting. Please type your questions into the Q&A widget that is open on the left-hand side of your screen. If you experience any technical difficulties during the presentation, click on the question mark icon below the presentation window. The presentation slides from today are available in the resources section. This presentation is being recorded and will be made available within the next few days on both Foley & Lardner's and Healthcare Appraisers websites. CLE credits are being offered for this program. We will be announcing the 5-digit code at some point during the presentation. Those seeking Kansas, New York, and New Jersey CLE credit are also required to complete the attorney affirmation form. Enter the 5-digit code that will be announced during the presentation on the form and return it to Kristen O'Neill at koneil, K-O-N-E-I-L-L, @foley.com immediately after the program. Now on to the main program. With me today are Thomas T.J. Ferrante from Foley & Lardner and Luis Argueso from Healthcare Appraisers. T.J. Ferrante is a senior counsel and a board-certified healthcare lawyer with Foley & Lardner, where he focuses his practice on telemedicine, telehealth, and virtual care, as well as a wide range of transactional and related regulatory issues for healthcare industry clients. Mr. Ferrante works with hospitals, health systems, providers, and startups to build telemedicine arrangements across the U.S. and internationally. He has experience with a variety of transactions, including mergers and acquisitions, joint ventures, strategic affiliations, obtaining and maintaining tax exemption, employment contracts and leases, and other transactional matters. Mr. Ferrante also advises healthcare clients in all aspects of federal and state regulatory matters, including anti-kickback, self-referral laws, state licensure, fee splitting, Medicare and Medicaid reimbursement, and compliance. Luis Argueso is a director in the Healthcare Appraisers Colorado office, where his practice involves the appraisal of healthcare businesses and valuation of healthcare provider compensation relationships. He specializes in the valuation of compensation arrangements between hospitals and medical groups with staff and medically direct hospital-based service lines, including anesthesiology, emergency hospitals, and radiology departments. He provides litigation support services for healthcare entities and consults with clients on improving efficiency, quality, and compliance of hospital-based service arrangements, and in the analysis of the economic impact of healthcare businesses. He holds a bachelor's degree in economics from Princeton University. And now I will turn to the main portion of the program. I would like to turn the presentation over to TJ to begin.
Great. Well, thank you, Kristen. I appreciate the introduction. My name is TJ Ferrante. I'm a healthcare attorney at Foley & Lardner. And today what we're going to do is we're going to have a discussion about telemedicine. And we're going to talk about some of the legal and compliance issues that telemedicine companies and providers experience out in the marketplace. And what we'll do is I'll just start off. I'll give some real-world examples of how we see telemedicine expanding, some of the models and the ways it's being used out in the marketplace. And then following that, get a little bit more into the weeds and explore some of the specific legal issues, such as licensing practice standards, other healthcare regulatory requirements. Talk about payment and reimbursement, why we separate those two terms. And then I'll hand it over to Louise, who's going to get into a discussion on the factors driving opinions of fair market value and commercial reasonableness related to telemedicine arrangements. We do hope we will leave some time here at the end for questions, and we highly encourage you to participate and take advantage of this Q&A portion of the presentation. We also have our contact info on the slides and materials, so by all means, I don't think Louise would mind me saying as well, feel free to reach out to either of us directly by email or phone after the presentation if you have any burning questions or follow-up or anything we didn't get to address during the discussion today. So don't hesitate to do that. Okay, so let's just jump right in here. I think, at Foley, I think it's fair to say that we do more telemedicine work than any other law firm in the country. And because of that, we've been fortunate. We've been able to work with some very large, sophisticated healthcare systems and providers who have substantial resources to devote to their telemedicine programs. But at the same time, we work with smaller, yet still very innovative and disruptive startup companies. And so it's great for us to have that vision of the, sort of the entire spectrum of telemedicine providers and deployment. And what we wanted to do is really we wanted to leverage that exposure. And back in 2014, our firm launched a survey and polled over 100 senior executives at, hospitals, specialty clinics, ancillary services, other healthcare-related organizations, physician groups, et cetera. And then we re-upped that survey again. We refreshed it just last year in 2017 to have it updated. Now, when we first conducted that survey, about 3 years ago in 2014, a little bit of a discouraging data point came out of that where the respondents to our survey, the majority, about 87%, said that they didn't expect that most of their patients would be using telemedicine in a number of years by 2017. So again, a little hesitation there, it seems like, out in the marketplace. Nevertheless, when we refreshed the survey last year, we received a totally different story. In that data update, we had about 3/4 of the respondents actually say that they are currently offering or planning to offer telemedicine services. And out of those who are planning to do so or currently are offering the services, over half, 53%, said that those services were actually growing or expanding. So again, I think it shows how far telemedicine really has advanced in really only a few years. Now, that said, we also tried to get some other interesting intel gleaned from the survey. And specifically, we're asking questions to give us information on what telemedicine executives and the leadership in those organizations perceive to be the major challenges in implementing telemedicine programs. And what we learned was that by far, and it wasn't too much of a surprise, was that the most citing concern was reimbursement, or really lack thereof of reimbursement. More than half of our respondents tagged third-party reimbursement as the greatest challenge to their implementation of the program. And even though about 3/4 of our respondents said that, yes, we are receiving some sort of reimbursement from third parties for these services or even cash pay, 1/3 of those said that the rates they were receiving were actually lower than the identical in-person services. So what I gather from that information is that, and again, no surprise, reimbursement remains a major pain point for the industry. Second most cited concern, and if you work in this space in a multi-state manner, it won't be a surprise. The second most cited concern was state licensing. Again, I'm sure many of you are familiar with that. And the reason I'm sharing this information on the webinar today is, one, I think these are interesting data points, but also to show that some of the issues that I want to highlight today are the type of things that are keeping telemedicine leadership teams and executives awake at night. These continue to be the main hurdles in areas where we need to find solutions to have successful programs. We do have copies of the survey in electronic format. I'm happy to share those. So if you'd like, you just email me or Kristen. I think we have our contact info in the materials. I'd be happy to give you a PDF of those or can mail you one. Again, I think it has some useful information that we were able to get. This slide is just to show, again, while I mentioned telemedicine issues and the legal hurdles of reimbursement and licensure, I want to point out that our presentation today is a little more nuanced and certainly isn't an exhaustive list of themes or areas for telemedicine providers. There are a number of other places and rocks to look under when you're building out these programs. And so I don't want you to forget about things like privacy and security, other contracting and credentialing issues, et cetera, just because we don't focus on those today. You do want to keep those at top of mind. but we are limited in our time, so we can only get into so many things. But do want you to be aware that there are a number of other items to check for when forming a program or maintaining one. All right, so let's go over some real-world applications where we see telemedicine being used today. One of my favorite concrete examples of how telemedicine technology is being utilized, and I would say in a very successful way, is within the context of online second opinion offerings. So what this slide does is it shows the sort of basic life cycle of how you would use an online specialty consult or second opinion program and turn it into a destination medicine, which is, in my opinion, ultimately what your ultimate ROI for those services. So to give an example, let's say we have, in our hypothetical, an academic medical center, and I'll just refer to that or call it AMC. And I sit in Tampa, Florida, so let's say the AMC is located in Florida. And we'll have a consulting oncologist, that specialist who works for the AMC. And then you have a patient, right? And that patient, in this example, let's say is located in Massachusetts. And they can find that AMC oncologist online, right? Especially nowadays with internet marketing. And that Massachusetts patient may have a primary care practitioner. And in this model, what you're really doing is focusing on a direct-to-consumer play. And what that means is the patient is going to initiate their request. So they're going to find the AMC online, right? Maybe you are the AMC in Florida or wherever that is known for their oncology or their cancer treatment. And so the patient is curious after reading up on this, but they don't necessarily want to make that big leap, that big jump, right, to fly out or drive out right away just for an initial consult, especially because at this point it's sort of speculative. So what you can do under this program is they get their local primary care physician to either e-sign or fill out like a one-page form where the primary care physician is the requesting physician. And what that form generally states is, yes, I am the patient's treating physician. I am requesting a consult from a Florida oncologist at the AMC. And then the AMC can charge for that consult, which will be delivered via telemedicine, usually in an asynchronous manner. And what the specialist will do then is then send the patient's primary care physician, that local physician, a copy of the second opinion report with a courtesy copy to the patient. The patient will view it. Usually it's very impressive with feelings like these are the people, these are the rock stars in the industry, the specialists. I want this place to be responsible for my care, the care of this disease. And so they can then reach out to the AMC patient intake, schedule the initial treatment for the session. And what you've done under this model is you've removed that entire need for that first speculative initial visit, in person at least. It's immediately reducing a significant cost barrier and a geographic barrier from a patient located in Massachusetts and that AMC physically located in Florida. And if you think about it, especially in today's market, right, if someone does have cancer or any other significant specialty disease, what's the first place these people are going? They're going to the internet, right? They're going to Google. They're going to go, and Google, what's wrong with me? They're going to be scared. They're going to be worried. They typically, they might reach out to their own primary care physician at first, but in most cases, they're not going to just jump right to a specialist, right? They're going to go talk to Google first and the internet. And if your organization is the one that pops up, right, it's going to be a great marketing advantage. I mean, right now, if you go on the internet or Google or on your phone and type in online second opinion offering, I guarantee you're going to see some of the big player medical centers as some of the first to come up in these search items. They're the ones that are getting and capturing a lot of these patients, right? It's not a secret anymore. And what you're doing is you're harnessing technology and you're using the internet for advertising, which, again, in my opinion, is a much better sort of approach than maybe putting up a bunch of billboards on the highway with LED displays showing ER wait times, right? So again, it's a very effective way to really blow out geographic boundaries and expand your reach from your hospital or your health system or whatever you consider to be your own center of excellence and market that appropriately. And again, that was sort of a direct-to-consumer type model because the patient initiates it. Another example of a DTC or direct-to-consumer model would be like the increased use of health systems of retail clinics. We've seen a lot of these, the proliferation of these as well. And they're really a convenient, low-cost avenue to receiving primary care services. So again, we talked about second opinion. You can really capture a lot of specialist activity. Hospitals, health systems, they're now also venturing into the low-cost primary care area as well. And this is a way to do that. So you've seen a lot of kiosks pop up in pharmacies, in grocery stores, and other national retailers. Now in these as well, you're going to have a lot of these fair market value and commercial reasonableness issues because you're going to have space leases, equipment leases for the technology, and sometimes even personnel leases or interactions as well. So there's a lot of fair market value issues that abound in those relationships. Those were two direct-to-consumer examples, and I don't want to just give one before moving on. That would be an example of an opportunity for like a B2B or an institution-to-institution example. So, within that you could have a telestroke arrangement between an academic medical center and a rural hospital, right? So, a lot of times the rural hospital doesn't have the patient volume to support an FTE neurologist, right? A full-time neurologist, or even if they do have one or maybe two, typically they don't have the level or at least the same level of expertise of an academic medical center in a much larger urban area that might have, like 8 to 10 on staff. And so these arrangements can be incredibly powerful and very effective telemedicine-based arrangements where the patient can go to the ED, the emergency department of the rural hospital. They can receive a telemedicine exam by a distant site physician at the AMC, who's then able to determine, very quickly whether or not to administer TPA, and can greatly reduce, your door-to-needle time for stroke patients. And what that does is it can exponentially improve your clinical outcomes, and it saves brain cells. It makes the quality of life for the patient that much better. And what you're doing is at the same time, it's also allowing that critical access hospital to continue to provide the type of care for the people who live in the community without having to, have its entire economics flipped upside down by being forced to hire a neurologist who's, only going to be maybe functioning at a 15% of their FTE capacity, which, I don't think is good for anybody. But again, even in this example, right, you're going to have this large distant site hospital, the AMC. The way it could be structured is they could have their own large staff of employed physicians, or could enter into a number of independent contractor arrangements. Maybe they have multiple on-call neurologists to staff and provide the telestroke services when needed. And so you could have these on-call neurologists receive a daily availability stipend or per consult fee. And because there's a number of different compensation structures, you're going to want to make sure that your FMV appraiser understands the responsibilities that the agreement covers and who's going to be billing for those services. So again, just wanted to give that as another B2B example. The point of all of this, I think, is a number of larger systems are doing a phenomenal job with becoming what I call a center for destination medicine. And going forward, I think what we're going to see in the marketplace is a further consolidation of expertise and patient awareness. Right? The patients will be going to places like your big brands, your Mayos, your MD Anderson, your Johns Hopkins, these big brands, and they will only grow bigger if they use telemedicine and online second opinions to grow their market share. I think you're also going to have like a brain drain from your local hospitals and cancer centers because your young, up-and-coming, very astute doctors are going to want to be working on exciting, complex stuff and will go to where the patients are. So not only is this like a patient care issue, but it's also a business decision as well for your long-term survival in the consolidating market. This next slide is just a quote from John Noseworthy, CEO of Mayo. And this actually comes from a few years ago now, but it kind of pushes the point I'm trying to make where he says, 10 years from now, there will emerge just a few medical centers with a reputation for excellence and patient-focused outcomes that will attract patients from all over the world. Again, I think this is really, we're starting to see this concept develop out in real-world application. And so if you are a local hospital, if you're a system, if you are a group or some other provider, I think this is something that you definitely want to focus on because I think it's where everything is trending. So to pivot very briefly, I do want to highlight the second most cited concern that I mentioned from our survey and just give a little bit of the lay of the land with respect to licensing. I'm sure many on this call are familiar that in the telemedicine context at least, your basic rule is that the physician or the healthcare provider must be licensed in the state that the patient is located at the time of the telemedicine visit or consult. So if your doctor is located in Texas and the patient is located in Florida, then the doctor must have a license in Florida, a medical license in Florida, in order to diagnose and treat the patient via telemedicine. And this is pretty much well established in every state. Now, for some practices that just focus on certain patient populations in their own state, this licensure requirement may not be a real big issue. But for other practices that may use an app or website platform to reach patients nationwide, it's likely the physician or your healthcare provider that you're using is going to need to be licensed in multiple states. And so what that means is the physician is going to need to submit multiple license applications, pay dues, and get CMEs. So, and again, I want to be clear, interstate licensing shouldn't be a showstopper for your program, but you do want to be aware of it because it can be an administrative burden. In response to a lot of these multi-licensing complexities, a number of compacts have sprouted up in an attempt to reduce these redundancies and streamline the interstate licensing process. So we have the Interstate Medical Licensure Compact now for physicians. I think 22 states have signed up for that. And then you also have, ones for nurses, your Nurse Licensure Compact. And then I like to throw out the last one here, which is your Federation of State Board of Physical Therapy. A lot of people are surprised, but physical therapy, we've seen a lot of activity in that space and in using telemedicine. Again, I won't get into the details of each compact here. Just want to make you aware that they exist and could be a useful tool if you have an interstate component to your program. So even though we have that basic licensure rule, there's a number of exceptions to licensure that are out there. These are the more common ones. So I won't go through each of them. You have your bordering state, your telemedicine license, and follow-up care. The only one I want to pull out very briefly is the consultation exception. And that's because it's probably the most common. We've seen it used the most in the marketplace, and almost every state has it. It also ties back to my earlier example on the model of a second opinion online offering. So what the consultation exception does is it allows an unlicensed physician to practice medicine in a peer-to-peer, doctor-to-doctor basis with a local licensed physician. So you could actually utilize this in about 40 states for that online second opinion offering model we talked about a few minutes ago. And conceptually, you can think about it in a manner that, the specialist is sort of standing in the primary care physician's shoes, where, in my opinion, I believe they are practicing medicine in the state where the patient is located, but you're doing so under an exception of the licensure requirement. Now, that said, there are some limitations as to what the specialist can and can't do, and the rule really varies significantly across states. So, for example, some states have limitations with respect to the frequency you can do the consults. A number of states say, oh, you can only do it infrequently, or some of them have a number you have to be less than 12 per year. A number of states prevent or address whether or not you can charge for that consult. This slide doesn't have it, but Alabama, for example, will prevent you, if you want to use this model, from charging for that consult. Some states exclude expressly radiology and pathology, right? They're kind of savvy to using that as sort of first reads or interpretations. So the point is when you're building out a national model that you're going to try to use an exception like this for, let's say, like an online second opinion offering, you just want to be careful and have a state-by-state understanding. And it also dictates sort of how you're going to staff these arrangements, if you are or are not going to get licensure for that. And again, if you have to add more personnel or different structures in that, then the payments between your system and the personnel, if you're going to be leasing or staffing in different ways, those will also highlight different fair market value considerations that we'll talk about later. Overall, though, I say this is a pretty useful exception. We've actually helped a number of clients build out programs using it, and it's proven to be, I would say, very successful. Okay, so practice standards. This slide is just a list of some of the more common practice standards. These come out of your boards of medicine, your boards of optometry, physical therapy, depending on your service line. They're typically more arbitrary than based on a clinical standard of care. Like them, don't like them, they do exist, so you want to be aware of them and comply accordingly. For example, over half the states require an informed consent be given to your patient at each telemedicine or prior to each telemedicine visit. So, you don't necessarily have to do that in an in-person visit every single time you see your primary care doctor. But there are rules in a number of states that require this in the specific telemedicine context. One practice standard I just want to quickly pull out, because I think it's important, is the modality. And when I say the word modality, what I mean is it's the type of technology, the way the communication is delivered between the patient and the provider, the way the healthcare services are delivered. And their modalities are typically grouped into 3 categories. The first and most commonly known is probably synchronous. And synchronous is your real-time interactive communication between the provider and the patient. So for that, I usually give the example of, think about like how you use Skype or FaceTime, where you can hear and see the provider, the patient can hear and see the provider in real time. That audio-video real-time synchronous communication is really considered the gold standard among telehealth modalities, so much so that I think it's all states now actually allow you to create a valid doctor-patient relationship without a prior in-person exam if you use that type of modality. So again, it's trended in a very favorable way for the telemedicine industry. The other modality is asynchronous, which is sometimes most commonly referred to as store and forward. And we've seen an explosion of this in teledermatology, telepathology, teleophthalmology. And to give you an example of how that works is, let's say you have a patient who has a skin issue or a rash, and they become worried about it. This technology would allow that patient, and it exists out in the marketplace today, to use a phone or a laptop, enter in some patient medical history, some patient medical information, take a few pictures or videos, using their phone even, of the area, of the skin-infected area, and then send all of that over, which can be reviewed by a physician at their own time, right? A dermatologist in their own time. That dermatologist can review the information and photos, determine a plan of care, depending on state law, write a script for skin cream or some other medication. And it can be a very powerful tool, because it allows the providers to time shift their delivery of care and to tackle a large group of consults at a single time in a more standardized manner on the dermatologist's own schedule, nights, weekends, whenever. And at the same time, right, it reduces patient waiting room time and increases that throughput and efficiency. So you don't have to necessarily now take a whole day off of work, take your kids or put them into daycare, travel to and sit in a waiting room, and spend more time traveling and waiting than you're actually going to see the dermatologist. And this is something that the market is demanding today, right? We all are used to, Amazon Prime or all that, getting something delivered in 2 hours, on-demand everything. And so this is a way that you can become more efficient as a system or a provider and using a technology like asynchronous. So I do think that's going to be trending and used much more frequently. That said, fewer states do allow you to create a physician-patient relationship without a prior in-person exam if you're only using async technology. It's changing, but there's still a number of states that prohibit it, and a number of states are silent in their laws on it. You could still, and we've advised clients on this and seen clients do this, you could still establish the physician-patient relationship using your synchronous, your real-time audiovisual, and then for the follow-up treatments, use your asynchronous. So it's not an exactly stop loss, but it's still there's some opportunity there. The last modality is RPM, or remote patient monitoring. That's typically you're using a lot of sensors and technology at the patient's home is the most common location, nursing homes, assisted living facilities, and the like. And you have data and ongoing monitoring of the patient being transmitted to a provider at a remote location. Technology or the software typically has like an algorithm where if there's an anomaly or something changed in the patient information being transmitted, that the nurse or the doctor can be alerted, and then they can review that information and intervene if necessary. And what you're doing in this case is you're not waiting for the patient to now have to travel to the doctor's office or the ER where the condition has become that much more severe, acute, or complex, but you're going to intervene earlier and provide that, maybe it's just reminding a patient they didn't take their medication for that day, and you're going to get in there earlier and provide better care at a lower cost. And some of the examples are, in diabetes, you see it with blood pressure monitoring, wireless scales, heart rates, et cetera. Those are the type of technologies that we've seen this used. Okay. So when you're performing a fair market value analysis and to understand the laws and risks that may be implicated by the telemedicine program, it's very important, and I think it's crucial to know from where you're receiving payment or reimbursement. And so I'll quickly talk about the Medicare fee-for-service methodology, how it's limited, how it's changed, but I'll also talk about other areas of potential revenue for telemedicine programs, which are Medicare Advantage, Medicaid managed care organizations, and your commercial insurance plans. So, I think the laws, as they do begin to change, and I'll talk more about that in a little bit, but as more government dollars pour into telemedicine service offerings, in more commercial dollars as well, I think it's going to really increase the scrutiny and oversight by HHS and the OIG, and also your commercial payers, right? So, you're going to want to make sure your programs are appropriately structured to comply with, your Stark, anti-kickback, et cetera, and that will involve the components of fair market value and commercial reasonableness requirements when applicable, and I think they're going to be increasingly important. So, Medicare does cover telehealth services, albeit it's limited, right? So here on this slide gives a number of the qualifying requirements that need to be met in order to bill for Medicare. The patient has to be in a qualifying rural area. Well, that means that the patient has to be in a health professional shortage area or outside a metropolitan statistical area. Easiest way to figure that out is if you Google telehealth eligibility analyzer, the HRSA website pops up. You can enter in the address, and it'll spit that info out for you. Patient can't be located at the patient's home. It's typically a medical facility like a physician office or a hospital or a SNF. You have to use that real-time synchronous audiovisual, so that that example I gave before with the dermatologist and the photos and sending that all off in asynchronous modality. You won't get paid for that by Medicare fee-for-service unless you're in one of the pilot programs in Alaska or Hawaii. Outside of that, that's not going to be an avenue for you. And then finally, you have to be actually using and providing one of the set of covered services, one of the CPT or HCPCS codes that's listed every year by CMS. So, what does this all mean? Well, what I think it all adds up to is that in 2016, CMS only paid about $29 million in total for claims reimbursement for telehealth services, which may seem like a lot, but when you compare it to the almost $700 billion Medicare budget, I think it really just shows that that number is immaterial and that people aren't using it because of the practical opportunities to meet the conditions of coverage are really just so limited. And, it's easy to kind of point the finger at CMS, but, going back, items 1 through 4 are really creatures of statute. In other words, it's going to take legislative action to change those. CMS, on number 5, has actually been pretty good about releasing codes. So, it's going to take some legislative actions to change that, which has been quite bipartisan on the Hill as of late. And one of the reasons I think that we haven't seen some action is because there's a lot of inherent tension and confusion on how telemedicine might affect the Medicare program. Some evangelists for telemedicine will say, oh, well, it's so great, it's going to reduce costs significantly, it's going to provide better care, better patient outcomes, it's going to be great and reduce the overall cost of the Medicare program. On the other side of that equation, some will argue, well, you're really actually just increasing access to care, and more patients are going to utilize this, and it's going to increase utilization and drive costs through the roof. So there's that ongoing debate. And the CBO, the Congressional Budget Office itself, has really struggled with this. Back when Medicare was first sort of evolving, they estimated from 2001 to 2005 it was going to cost the program $30 million a year, $150 million from 2001 to 2005. In reality, it only cost the program a total of $3 million. So it shows they've really just had a hard time wrapping their mind around, the impact telemedicine is going to have on Medicare fee-for-service. But after saying all of that, very recently we've had probably the most movement we've had legislatively in Medicare fee-for-service for telemedicine possibly ever. And earlier this year, in February, the Bipartisan Budget Act of 2018 was passed, and there were some big winners for telemedicine there. Some may argue it didn't go far enough. I'm a little bit more optimistic. I do think it's a step in the right direction. But just just real quickly, some of the highlights to it. If you have a telestroke program or somehow touch a telestroke or stroke, you should be jumping up and down. You got a big thumbs up from the legislature on this one. And starting in January 1, 2019, a lot of the geographic and facility type requirements on originating sites are going to be removed. And depending on how CMS ultimately promulgates the rules, sites like the patient's home, like ambulances, could be approved now originating sites to provide telestroke services and get reimbursed for it by Medicare fee-for-service. So again, how exactly that plays out will depend on the actual sites approved, but it could be a big opportunity for stroke programs. Similarly, home dialysis also got a head nod in this bill. You have now, under your home dialysis programs, the ability to provide telemedicine service oversight visits. You still have to have one in-person visit once a month for the first 3 months, and then once every 3 months thereafter. But again, it's a greater opportunity and opens up some payment there. That goes into effect 2019. Another key point on the home dialysis is there's a provision in the bill which says that the facilities you can actually give a Medicare beneficiary the equipment for free for the home dialysis. Typically if a client comes to me and says, oh, we want to give something for free to Medicare beneficiaries, I usually turn pale because it's very, very risky. There's a lot of restrictions on that. But this here, there's some actual statutory language which allows this under the bill. Medicare Advantage, I'll talk about that in a second. ACOs were another area that got some revenue opportunities added to them. You're going to be able to add a patient's home as an originating site starting in 2020 if you have an ACO that's a risk-based ACO. Won't spend much time here on Medicaid. This is very state-specific, especially fee-for-service. Most states do offer some telemedicine reimbursement. Async is trending. Some states have facility requirements. So you really, when you're building out programs, just have to look at the state-by-state rules there. One of the last things I'll talk about is just MA plans. In 2020, so it's a little bit more of a delay than some of the other provisions that began in 2019. But MA plans are going to be able to have some more opportunity. Medicare Advantage plans are generally encouraged to develop and implement innovative services. They are paid on a capitated basis by the government and told to go make it happen. And what that means is you can actually negotiate in contracts separately with these plans. And so plans are free to pay and reimburse for telemedicine services. Historically, one of the reasons that they haven't is because of the way that CMS had sort of done their accounting for their medical spend ratios. To put it in very simple terms, they basically made telehealth categorized as a supplemental benefit rather than a basic benefit. So it was more like telehealth looked like something like offering free gym memberships to your patients or members rather than a basic Medicare benefit. Well, what the budget bill did back in February is open this up, and it will allow MA plans to consider telehealth services to be your basic benefit. And I think that will really open up the door for payment. The specific services haven't been listed yet, but CMS is required to open up some public comment period by November of this year. So I would encourage you, if you have a specific service line you'd like to get compensation or payment for under an NA plan, to start that discussion now. There's no reason not to, and start to negotiate and talk about how you can amend or revise your plan documents to allow for that, because the plans know that this is coming down the pipeline. Okay. The last thing, just to move along quickly, I want to talk about is your commercial insurance coverage. This map shows the states that have some commercial insurance laws. About 35 states plus DC have some law in the books. And I think these are prime opportunities because you already have a law that says, health plan, you have to pay for this service. Without going into the nitty-gritty, I do want to just quickly talk about the differences between commercial insurance coverage and payment parity, because I think that's important. Your commercial insurance coverage law in a state will typically say something like, all right, health plan, if you are going to cover an in-person dermatology visit, then you also have to cover that service if it's delivered, that dermatology visit, if it's delivered via telemedicine. Payment parity is a little different. It talks more about the rates that the plan is going to pay the provider. And so that law might say something like, well, health plan, if you're going to pay $50 to your provider for an in-person dermatology visit, then you also have to pay $50 to a provider for a telemedicine dermatology visit. So your commercial coverage law is kind of more like a consumer rights issue because it's giving access and coverage of care to your members, where your payment parity is kind of more of like a business-to-business relationship between the provider and the plan. But it's important. A number of years ago in New York, they had a coverage law passed without payment parity, and one of the health plans started sending letters out, saying, okay, we will, abide by this coverage law, but we're only going to pay telemedicine visits at, 50% of our normal rates. And that can be very frustrating in some cases, in many cases, not even economically feasible for an online program. And the last thing I'll say about commercial plans or just payment in general is, even if your program is cash pay only, or even if it only takes commercial insurance and not Medicare or any other government money, sometimes we'll have clients say, well, we're not taking government dollars or commercial plans or et cetera, so I don't think we have to worry about Stark or kickback, or we don't have to concern ourselves with fair market value or commercial reasonableness. And I want to just make sure I highlight that that's not true, because many, if not most states, have their own state-level all-payer anti-kickback laws or their own, Stark law or patient self-referral law equivalents. And so you do want to structure your programs to be compliant with these laws and compliant with the fair market value and commercial reasonableness requirements where applicable, regardless of your, government involvement or not. And so with that, I do want to hand it over now to Louise, who's going to get into a little bit more detail on the actual FMV and the commercial reasonableness issues. Louise, I'll pass it on to you.
Great. Thank you, TJ. I really appreciate that excellent transition and excellent coverage of the legal issues associated with telemedicine arrangements. What I'd like to do with my time is cover a couple of things. I'd like to start with some of the trends that we here at Healthcare Appraisers have observed with regards to the telemedicine industry and telemedicine arrangements and businesses. I'd like to move on then to covering some of the the regulatory landscape related to these arrangements, why fair market value matters, why commercial reasonableness matters. And then finally, I'd like to round it out by covering a lot of the key considerations that we look at when we're providing opinions of fair market value and commercial reasonableness. So to start out, what has Healthcare Appraisers seen? Well, in my practice, just to give some background, I started with valuing hospital-based service arrangements, looking at service lines like emergency medicine, anesthesiology, hospitalist medicine. And one of the things that I've observed in my 10 years working in the valuation industry is the emergence of this telemedicine industry. And it's really a function of improving technology and also a lack of availability and supply of providers and much needed specialties. And so really where we've seen here at Healthcare Appraisers, and me personally, where I've seen a lot of arrangements is in the hospital-based telemedicine arrangements. Service lines like teleneurology, telestroke, telepsychiatry, EICU, tele-ICU, and teleradiology. And our arrangements, the arrangements that we've been taking a look at, largely started with rural marketplaces where really telemedicine was the only option that many facilities had with regard to attaining coverage. But we're seeing this telemedicine service line expand into ex-urban areas, urban areas. I think TJ did an excellent job giving some examples of direct-to-consumer service offerings, and we work more in the kind of business-to-business space. So where do we Healthcare Appraisers see future growth? Well, I think we see a lot of potential for growth in the telehospitalist and teleemergency world as facilities see an even greater shrinking of the pool of available physicians and advanced practice professionals who are willing to provide coverage. We're seeing a lot of growth in many states in the prevalence of freestanding emergency departments. And as the demand for physicians increases to staff those emergency departments, there's certainly going to be more pressure on some of these facilities that have difficulty accessing providers to attain much needed coverage. So to kind of build off of some of the observations that TJ had with regard to telemedicine, I think the survey that he cited that his firm produced regarding the growth in telemedicine is really apt and really kind of backed up by this data here. What this graph here presents is the growth in the number of allowed Medicare inpatient telemedicine consultations. And you can see a very significant increase and almost spiking in volume from 2013 to 2014, and that trend kind of continuing on into the future. Of course, along with the growth in Medicare spending comes scrutiny. I think TJ did a great job kind of discussing this. You know, CMS really does, and especially the Office of Inspector General, really do see themselves as stewards of the taxpayer's dollar. And so anytime they start to open the spigot with regards to paying for services, there's definitely going to be scrutiny. And one recent development is that the Department of Health and Human Services Office of Inspector General put payment for telehealth services on their work plan. And the first kind of work product that they released along with that initiative was this report, which came out recently in April 2018, titled CMS Paid Practitioners for Telehealth Services That Did Not Meet Medicare Requirements. I think TJ did a good job covering kind of the five main telemedicine reimbursement requirements. And what this report did is it went back, looked at some of the reimbursement that it paid to providers, really scrutinized the records and determined that there was a lot of reimbursement that they made that did not meet the requirements that were set forth in their in Medicare's regulations. I think what this really highlights, in addition to the fact that there's a lot of attention being placed on these arrangements, is the importance with making sure that whether you're a hospital or a telemedicine provider, you're working with a partner, whether that be a law firm or a valuation company that really understands the marketplace, that's keeping abreast of the latest developments, because it is an industry, as a new industry, where there's a lot of uncertainty and a lot of, in some cases, ambiguity regarding market standards. Moving along, I do want to cover some of the recent developments that we've observed. I think in the telemedicine industry, I think TJ did an excellent job covering the 2018 bipartisan budget. As part of that budget, they incorporated what was called this Chronic Care Act, and that included a number of the provisions that TJ talked about with regard to easing on some of the conditions required to be reimbursed by Medicare for healthcare services. Some other recent developments to build off on the information that TJ covered. There recently was completed what was called the Dawn trial. This was a very large study in the world of treatment of stroke. And what that study found was that the kind of gold standard of making sure that a patient receives treatment within a 6-hour window could be expanded to a 24-hour window for patients who meet certain clinical criteria. I'll leave that for a physician to comment upon, but nonetheless, kind of expanding the window in which treatment can be provided has, what we've heard from our clients, is expanded the expected demand and need for neurology coverage. And as in some marketplaces, neurologists either are just not available, or they choose to practice in an outpatient setting and not provide inpatient care. That's only going to increase the demand for these providers. Additionally, there have been statements and potential legislation that's been raised with regard to the opioid crisis. Currently, providers are restricted from prescribing certain controlled substances over telemedicine, and there's been some discussions about possibly easing those restrictions for the purpose of allowing physicians to prescribe treatment for basically to prescribe opioid antagonists for patients who are suffering from addiction to opioids. So that's a highlight of some of the recent trends. As it complements the information covered by TJ, we're really seeing an increase in the utilization of these services, and I think that increase is only going to accelerate into the future, given a lot of the items that we've covered so far. So switching gears now, I want to take some time to cover the compensation compliance landscape when it comes to these telemedicine arrangements. I'd like to spend some time covering why it's important to care about compensation compliance and what really that landscape looks like from the evaluator's perspective. So the first question that one might think of if they're not really familiar with this industry is, why should I care? Why really should I care about compensation compliance? Well, I think that slide does a good job of illustrating why it's important to care. This is information pulled from the Department of Health and Human Services OIG semi-annual report to Congress, the most recent one, and they indicated that for 2017 they expected investigative recoveries were going to total $4.13 billion. And just to give you a sense of the scale of that amount of money, that is the approximate GDP of, you can see the little map there, Montenegro. So this is a very substantial amount of money, and it's and part of the reason why those recoveries are as large as they are is because the penalties for not complying with START and anti-kickback statutes are very substantial. There's a per violation penalty, and on top of that, there are treble damages for each instance of violation. So you can talk about penalties reaching massive amounts. So when looking at the landscape, there's three kind of key areas to be aware of. Those are the Stark Law, the anti-kickback statute, and IRS prohibitions on private inurement. So let's start with the Stark Law. The Stark Law essentially prohibits a physician from making referrals for certain what are called designated health services payable by Medicare to an entity with which he or she or an immediate family member has a financial relationship, unless a certain exemption applies. So I do want to cover what falls in the bucket of designated health services. There's if you just Google designated health services, Medicare has a very exhaustive list, but it does include things like clinical laboratory services, radiology and certain other imaging services, and inpatient and outpatient hospital services, all the sorts of things that a telemedicine provider may refer a patient to if they're consulting, say, a patient that's an inpatient at a hospital. So certainly telemedicine is implicated when it comes to the Stark Law. Now, the important exemptions that we come across in our work is that when it comes to complying with the Stark Law, the compensation has to be consistent with fair market value, and it has to be considered to be commercially reasonable. Now, it's also important to note that the Stark Law intent does not matter. So even if you entered into an arrangement with the best of intentions and you had no intent to be paid for the volume or value of referrals, it doesn't matter. It's a strict liability statute, and so you will be considered in violation if you do not meet the exemptions that are set forth within that statute. Or that law, excuse me. For the anti-kickback statute, the federal anti-kickback statute is a criminal statute that prohibits the exchange or offer to exchange of anything of value in an effort to induce or reward the referral of federal health care program businesses. The anti-kickback statute also has exemptions that are similar to those that apply to the Stark Law. Finally, I think it's important as well to mention prohibitions on private inurement that are set forth in the IRS. So this applies to our nonprofit healthcare entities. Those entities must comply with the IRS code, and one of the tests that the code uses to establish that an organization is being operated for a tax-exempt purpose is the following. Basically, the test prohibits that what's called the net earnings of the organization do not inure to the benefit of private shareholders or individuals. And this, even though they use the term net earnings, that doesn't necessarily mean the earnings left over or after subtracting costs from revenue. It's been interpreted to apply to all revenue. So when it comes to telemedicine arrangements, if you're a nonprofit entity, you need to ensure that the compensation is considered fair market value and to ensure that it complies with the prohibition against private inurement. So that's just kind of a brief summary of the regulatory landscape. I would highly encourage folks listening who have further questions to consult an attorney, certainly a legal mind better than mine, and I think the folks at Foley and Lardner would be more than happy to oblige. So one of the things that I did want to discuss here is what are referrals for designated health services, because I think there's a lot of questions in this realm when it comes to, well, does telemedicine really implicate these laws and doctrines? And the answer to that is yes, and I want to kind of cover a couple of examples. So I already discussed the ordering of imaging or lab services. I do want to also discuss the hub and spoke model of telemedicine. So this is where you have a facility, a hub facility, that is kind of the center and home base for which healthcare services are provided. I think a great example that TJ brought up is that kind of destination medicine entity. Well, it is very common for that very popular, well-known, great reputation entity to enter into telemedicine arrangements with what are called spoke facilities that are considered to be somewhat part of the marketplace that the facility is located in, such that if those facilities wanted to refer their patient to a higher level of care, they may consider referring that patient to the hub facility. And in those instances, there's a potential what's called a reverse kickback scenario, where the hub facility may be considered to be violating the Stark and anti-kickback statutes if they are undercharging those spoke facilities for the services that they're providing, and that's interpreted as an inducement for those spoke facilities to refer patients to those hub facilities. Of course, there are certain elements of community benefit that apply to a lot of these hub facilities, and those are taken into account in evaluation analysis, but it is important to highlight that that is an instance of potential implication of these laws. Another instance is when you have primary care telemedicine referrals to specialists. So that might exist in the direct-to-consumer model, where a consumer comes to a primary care physician via telemedicine and they refer that patient to a specialist. So the key concepts when looking at this regulatory landscape are commercial reasonableness and fair market value. Those are what we provide opinions on here at Fair Market Value. And essentially, commercial reasonableness is basically it puts the question, does this transaction make business sense? Is this a transaction that individuals on the marketplace are entering into? And then with regard to fair market value, the test there is this what a buyer and seller would agree to without consideration of the volume of referrals? And so this is essentially saying, what is someone in the open marketplace going to pay for a service if they weren't in a position to potentially receive referrals from the entity that they're paying for these services? So all that said, let's talk about our key considerations when it relates to commercial reasonableness and fair market value. And what these are really a development of our and summation of healthcare appraisers' kind of expertise in the realm of looking at telemedicine service arrangements and, to a lesser extent, valuation of telemedicine business entities. So first, talking about commercial reasonableness, what we're really looking for here is to determine if the arrangement or transaction serves a legitimate business purpose. One of the things that we do to test that is we look and see if the arrangement is consistent with the practices of market participants. So we really do try to solicit feedback from our clients and the providers with whom they're entering into arrangement with to determine, what is the marketplace, what are we seeing in the marketplace when it comes to these telemedicine arrangements. And given that it's a new and evolving industry, that's something that, it's important to stay on top of and follow regularly. Additionally, on top of that, when we're looking at commercial reasonableness, we want to make sure that there's a matching between the scope of the services or the transaction and the business need. So a great example of a mismatch between the scope of the services and the business need would be, say, a medical director arrangement calling for a full-time compensation for 20-80 hours, a full-time medical director, related to, say, a small nursery within a hospital. There, while it's commercially reasonable to have a medical directorship, there's a mismatching as well of the scope of the service and what is needed in that instance. So here I want to provide some examples of business purposes that we've seen with regard to telemedicine arrangements. So the most common one that we run into here at Healthcare Appraisers are facilities securing coverage of key service lines for rural or underserved communities. So this would be the example for that I think TJ did a good job walking through of the tele-stroke program that you'll see in your rural facility, critical access hospital that might not have access to a neurologist. This is something that the OIG has issued an advisory opinion on when it comes to teleneurology arrangements, and looked favorably upon arrangements that essentially secured this coverage because at the end of the day, they're really accruing to the benefit of patients. They were making sure that costly transfers were avoided. And as the saying goes in the neurology sort of clinical service line, time is brain. And so the quicker that you can get treatment to a patient, the better. So that's an example of a commercially reasonable purpose for a telemedicine arrangement. Additionally, there's some facilities that have very limited access to providers. You know, a hospital that may, say, have access to one employed full-time equivalent intensive care physician, and so they need to expand that coverage to the after hours period of the day, and so they might enter into an arrangement to cover outside of the normal business hours through a EICU service. Finally, there are examples of developing telemedicine service lines to kind of expand a service area beyond a local community. I think TJ did an excellent example covering some of the direct-to-consumer options that are being out there, whether it's accessing a second opinion on a website or whether it be setting up a kiosk in a grocery store to enable patients to receive health care. So in this slide here, I don't want to take too much time on it. Afterwards, folks can review it. But as I mentioned before, one of the things that we look at is what's being done in the marketplace. And so we've kind of summarized our observations in this table of the different types of payment mechanisms that we've observed in telemedicine arrangements and how they what sort of service lines they apply to, as well as giving kind of a brief description of each. So as you can see here, there's a lot of different payment mechanisms out there in the marketplace. It's a fairly young industry, so we're seeing a lot of variety. And this is kind of a helpful guidepost to showing, all right, what are other market participants doing? So now that we've talked about commercial reasonableness, let's cover fair market value. I want to highlight here a couple of the important components of the definition of fair market value. I won't read the full definition. It's certainly very long and very, you can tell it was written by lawyers and regulators. No offense to the folks at Foley and TJ. But I do want to highlight a couple of the important components of the definition of fair market value. The first thing that I'd like to highlight is that it involves a transaction or arrangement between hypothetical, willing, and able buyers and sellers who are under no compulsion to buy or sell. So these are buyers and sellers who are buying and selling their services, not in a, say a setting of liquidation. They need to liquidate the assets that they have or the services that they're offering. Also, they're acting in arm's length. So there's no real strategic or synergistic value that's going into the value of the service being provided here. In the context of healthcare, it's very specific that this compensation, that the compensation for it to be considered fair market value, it cannot consider the value or volume of referrals associated with the transaction. So what do I mean there? What's an example of a non-compliant arrangement that would definitely raise the regulator's ire? Well, one can imagine a telemedicine arrangement where the hospital and telemedicine service get together and say, the hospital says, well, if I don't transfer these, stroke patients, I'm going to accrue an extra $1 million in revenue, total revenue. So what we'll do is we'll share 50% of the additional revenue that we generate from you providing this telemedicine service availability. That would be an example of an arrangement that would not be compliant and would be kind of violate that tying the compensation to the volume and value of referrals. Finally, what we as evaluators are tasked to do with regard to these service arrangements and businesses is match the value to the level of service or to the business being delivered. And so as I go through these items that we consider to be value drivers in the world of the fair market value of telemedicine arrangements, really what we're trying to do there is identify the elements that match directly to the value and to the level of service that these telemedicine service providers are rendering. So before I hop into the value drivers, I do want to highlight the importance of understanding that telemedicine arrangements are not on-call arrangements. Telemedicine arrangements are not, reimbursement for CPT code arrangements. What we here at Healthcare Appraisers make sure we spend time on is really understanding these telemedicine businesses, really understanding the differentiators that these businesses have relative to your standard on-call arrangement. Paying a physician to carry a beeper around 24/7 so that they can answer a phone call is a lot different than operating the technological infrastructure needed to enable a live video conference between a physician and a patient at a moment's notice on a 24/7 basis. And so while these value drivers may come up in the valuation of on-call arrangements or in the valuation of arrangements involving payment per procedure, certainly on a holistic perspective, it's different, and there are items in these arrangements and businesses that differ from what we see in those other types of arrangements. So let's talk about some of those value drivers that we've seen. First, the first value driver is going to be the availability of the service. And we kind of break this down into two components. First, what are the hours of operation? And second, what's the expected response time? So I gave the example of an intensive care physician needed to be covered after normal business hours. So for example, in that arrangement, you would have hours of operation outside of normal business hours. Well, it's certainly easy to imagine as well an arrangement that calls for 24/7 telemedicine availability. So that's going to drive the value of these services. Additionally, the expected response time is very important to take a look at. There are certain services, for example, telestroke, that require very prompt response time on the part of the telemedicine provider in order to ensure the best level of patient care. There are other services, whether it be the asynchronous store and forward services that TJ mentioned, that do not necessarily require the same level of response, and as a result, that's going to have an impact on value. The second value driver that we look at is the specialty. So what sort of medical specialty is involved? This is pretty straightforward. Most telemedicine businesses kind of specify what service is involved, where sometimes there's some nuances in what the hypothetical provider would be paid for the service. So just because you have a neurosurgeon who's providing the teleneurology consults for less acute patients doesn't necessarily mean that you can be paying neurosurgeon rates for that service if that's not what a hypothetical provider in the marketplace would do. The third thing we look at is the provider type. So who's actually delivering the healthcare services? And this can vary widely. It can vary from a physician to an advanced practice professional like a nurse practitioner to other providers that are able to bill for services such as counselors in the context of a telepsychiatry arrangement. One thing that we at Healthcare Appraisers like to understand when we're valuing our telemedicine service arrangements is, in addition to the individuals delivering the service, who are the clinical support staffers that are required to enable this service? So unlike, say, a physician taking call coverage, we're well aware that telemedicine businesses often require nurses, for example, to help document the service that occurred. And so in addition to looking at who's actually delivering the service, we also want to consider what's the level of clinical support staff involved in providing the service. The fourth thing that we look at is frequency. How often is this telemedicine service utilized? This oftentimes will run into scenarios where the payment mechanism associated with the service line may not necessarily call for payment of certain telemedicine events, but that doesn't necessarily mean that the burden of the frequency of those events should be excluded. So certainly we want to make sure we have a holistic understanding of the telemedicine services that are, the frequency of the services that are provided. So moving on to the next kind of page of value drivers, hand in hand with the frequency comes the level of care. So how complex is the service that's being provided? Is this an initial inpatient assessment where full history and physical of the patient needs to be undertaken, where the level of medical decision making reaches a very high level of complexity, or is it a subsequent care inpatient round on a low acuity of patient? Those sorts of the level of complexity of the service being delivered is also going to be a component of the value that we consider in our analyses. Next, we also look at alternatives. So absent the telemedicine service line, what other service lines could be used? And for many of our clients and many of the arrangements that we look at, there often isn't an economically viable alternative. Oftentimes, telemedicine is the only option. So otherwise, you're talking about looking at bringing in a locum tenens provider, and the volume at the facility might not necessarily make sense from the perspective of the hospital to pay to bring someone from outside the marketplace, house that individual, cover their travel, and food and meals as well. The alternatives also play a role in when it comes to us assessing what's the level of compensation that we would expect a provider to earn, a hypothetical provider to earn providing the service. The next item that we look at is the payment mechanism. This is less so a value driver and more so making sure that the opinion that we provide is structured and tailored to how the services are paid for. And in that slide that I presented earlier, this can range very widely from a payment per event to just a flat availability fee, paying a fixed fee per year to enable the service. And so the way the payment mechanism is structured is going to have an impact on our value, on our valuation. Say, for example, if we're looking at a service line in which there's a number of different potential volume scenarios and there's only a single fixed fee being paid, we need to make sure that regardless of the volume scenario, that the fixed fee makes sense in light of the potential utilization of the service. The last item on this page are what I call extras, and these are very important and often get overlooked in valuations when it comes to telemedicine arrangements. These are things like setup and implementation costs. One of the things that we've certainly heard very frequently from telemedicine businesses is it takes a lot to get a system up and running. It takes a lot to get integrated into the EHR. It takes a lot to get providers on the site trained with using the service, and that is, a cost that is certainly relevant and should be considered in evaluation analysis. On top of that, as TJ mentioned in some of his early examples, you've got technology costs associated with fixed assets like telemedicine carts. In some instances, there's software being provided. And then also there's items like support costs. So in addition to the clinical support staff that I mentioned, there's also tech support that needs to be provided in order to enable the service. So for example, unlike a call arrangement where a physician really needs to have a phone on them that's working at all times, when it comes to a telemedicine service arrangement, the telemedicine provider needs to be able to respond on a 24/7 basis and oftentimes using a live video, which is going to use a lot of bandwidth. So having a really solid tech support team in which response time is of the essence is definitely a cost that we're going to consider in analysis. To round out some of the final value drivers of telemedicine that we look at, important to look at is the modality of care. I think TJ did an excellent job talking about the differences between the synchronous live video, asynchronous store and forward, and remote monitoring, so I won't go into detail there. But also very important, and I want to end on this note, is the reimbursement. I think TJ did an excellent job talking about how this is going to have an impact on the fair market value analysis. So what is the expected professional revenue from this service? And given the state of the industry, where there's a lot of uncertainty around this reimbursement, where a lot of reimbursement policies are changing, I think it's important for the parties involved in any valuation to make their best effort at getting a sense of what revenue is going to look like. Currently, I would say the modal response that we hear from most providers is that they're just not billing and collecting for the professional revenue component of the services, given a lot of the restrictions. At some point, it's going to become an open commercial reasonableness question as to whether or not it's commercially reasonable to expect whether or not a hypothetical telemedicine provider should or should not be billing and collecting for the service. And we'll want to make sure that once these restrictions on reimbursement are eased, the parties are making their best efforts to come up with a revenue estimate so that can be taken into account in the valuation. So with that said, that covers the material that I had prepared for our slides. So I thank TJ for his introduction, for covering his material. And I'd like to kick it over to Kirsten for a CLE announcement.
Thanks, Luis. So at this time, I'm going to read the CLE code for this program. So if you are in need of CLE credit today, please enter the 5-digit code that I'm going to announce into the polling question that will appear on the screen after the announcement. Once you enter the 5-digit code, please hit submit. The code is as follows: 9, N as in Nancy, H, 9K. Again, 9, N as in Nancy, H, 9K. And I've opened the poll. Again, if you are seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those seeking Kansas, New York, and New Jersey credit, in addition to the polling question, you'll need to complete the attorney affirmation form and return it immediately after the program. A copy of the form can be found in the resource list widget. As a reminder, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. Okay, at this time, the poll is now closed. Now we're going to turn it over and open it up to the question portion of our program. Again, please use the Q&A widget on the left-hand side to type in any questions that you may have, and we've already received quite a few. So we're going to just start by taking those questions. And if we don't get to every question today, we will review and reach back out to the folks who have submitted those questions with answers. Okay, first question. Are there any fees as a percent of collections? Is there danger that this is a form of fee splitting?
Sure, this is TJ. I'll handle this one, and then maybe I'll ask you, Louise, if you see a lot of percent of collections arrangements. But we definitely have seen compensation arrangements structured on a percentage basis. To give the all-famous lawyer answer, it really depends, right? Because it's going to depend on the details of the arrangement and how it's structured. Most importantly, I think it might depend on what state you're operating in. So, for example, Florida has a state law prohibition on percentage-based arrangements if the arrangement involves marketing services, if those are involved. Other hostile states are like states like Illinois, New York, California. They have some fee-splitting laws that you have to be careful of. And then, you know, my perspective is if you're going to build out a model to scale and you eventually want to be in most or all states, I'd highly recommend using, the most conservative or a more conservative structure so that then you can scale with confidence in a uniform manner rather than having, one structure in one state, another in this state, and another in a third state, and you're at risk of having a foot fault because, your operations are different in each location. So there's no blanket prohibition. I want to just make that clear. But again, it'll depend on the state law within which you're operating and, again, the other considerations of how the arrangement or deal is structured. But I don't know, Luis, have you seen that quite a bit?
I have not, but again, that's a lot of that's a component of seeing most of the hospital-based world. The one thing I will say is the key that is if a payment is structured on a percent of collections basis, there needs to be some documentation that percentage is matching the level of service being delivered, so that there was some diligence done to ensure that whatever ultimate percentage that was selected ties directly to the level of effort on the part of the entity receiving that collections percentage.
Okay. Actually, I'm going to go back to the CLE code. I've just been getting a little bit of confusion, so I'm going to read it again. The code is 9, N as in Nancy, H as in hot, 9, K as in Kristen. Again, it's 9, N as in Nancy, H as in hot, 9, K. And I've opened up the polling window again. Okay, while folks are entering that, I'm going to actually move on and ask the next question. Regarding primary care referral to specialists, is it acceptable to refer within your own group? If I refer to a specialist within my own niche telemedicine company and I am the owner of that company, is this a violation?
So this is TJ. I'll take this one. Again, to start off, it's another depends answer, unfortunately. We've definitely seen structures that you can do this, right? If you are self-referring, however, if you're self-referring for designated health services to your own group, forget whether or not telemedicine is involved. Just from a in-person or typical healthcare perspective, you're definitely going to have to look at that arrangement and whether or not it implicates the Stark and kickback laws. Those likely will be implicated if designated health services are involved. And that's not only if you're accepting or taking Medicare, but again, as I mentioned during the presentation, a lot of states have their own anti-kickback versions and also patient self-referral. But there are compliant ways to do it, right? So one of the most common ones, or the ones I see a lot, are, for example, if you can meet the definition of a group practice under the Stark law, you might be able to use the in-office ancillary services exception to shield yourself from the Stark law. It's a very complicated exception, but it's utilized quite a bit. That's how you see these big physician groups who might also house, pharmacy. They might also house imaging, and they all refer within. The way they do that compliantly is by structuring themselves as a group practice and taking advantage of that Stark law exception. Again, you'd have to look at the state law as well, in addition to your federal law, if you're taking Medicare, because sometimes states have funky rules and requirements as well. Florida, for example, has a requirement with respect to imaging and how only no more than 15% can be from outside sources. So that's just a little bit of a flavor. So I guess the short answer would be yes, you can do it. There's groups out there that do it, but the big caveat, the big but is I've also definitely seen structures out there that are not compliant and would be violative of the Stark law or possess risk under the anti-kickback statute. So don't want to discourage you if that's your business model. You just might have to get somebody to help you take a look at it more closely.
Thanks for that. Okay, on to the next question. Is there any restriction for a physician seeing a patient in a state he is licensed in, but for which he no longer lives in?
So is there any restriction for a physician seeing a patient in a state he is licensed in, but for which he no longer lives in? I'm not aware of any. Again, what matters, as long as that doctor or physician is licensed where the patient is located, that's your general rule. The only situation I think that might be problematic is for Medicare. Medicare has a general rule that the provider has to be located within the United States. So, you have a lot of Nighthawk programs or other international arrangements. If your doctor's located physically in, let's say, Israel, you can provide services. There's no restriction from a medical practice of practicing medicine that doctor couldn't do that if he's licensed. But then you couldn't build a Medicare program for it because of that payment rule. So I think that's generally fine. And in fact, a lot of times doctors will become licensed in multiple states if they're employed or contracted with a telemedicine program. So then they can provide services to patients in a number of different states. So a lot of times we'll recommend even doctors get licensed in all 50 states or as many as possible, and then their footprint and ability to see patients is larger.
Okay, on to the next question. Can a health system bill both the professional fee and the originating site fee if it owns both the distant and originating sites and the professional works in the health system?
So this is TJ again. Can the health system bill both the professional fee and the originating site fee if it owns both? Yes, you can do that. It's a little complicated. The Medicaid, the manuals go through it, and I'm assuming the question is tied to Medicare. So yes, you can have like the distant site physician can reassign his or her right to bill. So the nuances are that let's say you have like the health system is in California, right? The hospital, the originating site would be enrolled in the MAC jurisdiction of California, which I believe is Meridian. But let's say that the doctor then is physically located here in Florida where I am. So that physician and that doctor can reassign his or her right to bill for the professional piece to it, but the California hospital must be enrolled in and must bill to the MAC jurisdiction for Florida, and which is First Coast. And that's where you would send the professional fee. And then you would use, you have your place of service code. You want to have telemedicine location for that. Well, that's generally how you would do it, if I'm understanding the question correctly.
Okay, on to the next question. Are there tables or benchmarks available for on-call compensation?
Yep, this is Luis. I'll hop onto this one. There are a couple of sources out there that publish compensation benchmarks as it relates to on-call arrangements. Two of the ones that come to mind are MGMA, the Medical Group Management Association, and SEA, Sullivan Cotter Associates. In the telemedicine world, there's very limited benchmark data available. I am aware of one firm that produces those benchmarks on a regular basis, and that's MD Ranger, MD Ranger. One word of caution with regard to those numbers. As we covered in the number of items that determine the value of coverage and the value drivers, those items you're not going to have access to when you're looking at this benchmark data. So you're not going to see how frequently the service was used. You're not going to see what the reimbursement potential looked like for those types of arrangements. And so from a fair market value perspective, we'd caution using just looking at the benchmark data for the perspective of determining fair market value, but certainly can provide a helpful kind of guidepost to see what's in the marketplace.
Okay, on to the next question. What is considered a designated practitioner?
Designated. This is TJ. I'm not really sure what that term refers to. I think if you're talking about the type of practitioner to the Medicare that will be qualified, there's a list of those, right? So those are like your physicians, nurse practitioners, PAs, CNSs, CRNs. I think clinical psychologists and social workers to some level. So for example, like physical therapists would not be qualified distant site practitioners. You couldn't bill from Medicare under that.
Okay, the next question. We are a small niche direct-to-consumer telehealth company. When we don't have enough providers to meet a need, such as a specialist or after-hours coverage, our telehealth platform automatically refers to one of the 900 providers of our collaborating telehealth company, the company who sees the patient bills. Is this a problem regarding referrals?
So it sounds like what you're doing is you want to be able to staff your model so you have 24-hour call or whatever, and so you're contracting out to another company to offer that coverage. That's pretty typical. In the company who sees the patient bills, I'm assuming that's the other staffing company. That shouldn't be a problem because they're going to be providing the professional piece to that. They can bill for the professional. It depends if they're billing, again, Medicare, if there's some other commercial. If it's commercial, you always have to look at your commercial contract to see if there's any weird rules. I'm not aware of any off the top of my head. For Medicare purposes, again, you could have the that billing be done by the other company, or it can be reassigned. And then you would have the compensation arrangement between your company, the telemedicine company, and the individual contracted group. So you could pay them on a availability basis. Typically, we like to have flat fees, but again, it would depend on what state you're in. As far as referrals, the only way you might have some problems with referrals is if there's some weird relationship between that third-party contracting employed physician and where they're referring it to. As far as if they referred to their own group, if they were just moonlighting and they referred it to their own group, and then again that would likely put them in hot water more than you. But that would be the only problem I think with respect to the referrals that you would want to be careful of.
Okay, we have time for one last question, and I know we did receive a number of questions, and we will get follow-up after the program. An urgent care center has a policy of having its general x-rays overread by a radiologist. The fee will not be passed on to the patients, but paid as an admin fee for QA purposes. What is the going rate being seen, for example, $10 per study? Is there a charge for storage of digital x-rays? What are the ranges being paid?
Yeah, so this is very common in the teleradiology world. The fees really vary depending on the modality of image being interpreted. The X-ray fees are typically going to be, more in the range of, single dollars to $12, $20, that sort of market band. Outside of that, whether it's an MRI, CT, any sort of more complicated study, the fees can range very widely from anywhere from like $30 to $100. A good place to look for that is to get quotes from a teleradiology company. They're pretty competitive, and the marketplace is pretty consistent when it comes to pricing. With regard to the storage of the images, I have not heard or run into any sort of fees being paid for storage of the images to date.
Thanks, Luis. Well, at this time, we are a little bit over, so we're going to wrap it up for today. I would like to thank Luis and TJ for an excellent presentation today. And we do invite you to contact either of today's speakers. I have put their contact information up on the screen right now. And again, you are able to download the slides. They're currently in the resources section, so please feel free to download the slides if you would like to take them. This wraps up our web conference today. Just a reminder that today's program is being recorded and will be available on both Foley and Healthcare Appraisers websites within the next few days. At the conclusion of this program, a questionnaire will appear. Please take a minute or two to give us feedback on the presentation today. It's very important to us to know your thoughts and help shape our programs moving forward. And if anybody has any questions, please feel free to contact me at Kristen O'Neill, KONEILL @Foley.com. Thank you for being a part of today's presentation.